Welcome to the Bills Committee on Employment Amendment Bill 2020 first meeting. May I remind members that during the meeting that you must use the virtual background as well as turning on your camera to show your face. And the attendees must take part within Hong Kong for this remote meeting. First, I would like to talk about inviting public views. I'd like to consult members on the proposal to invite members to make written submissions. Do you think we should stay with written submissions or any other format? Well, since the pandemic is still raging, that we can put up a notice on the lecture website and invite the public to air their views in a written submission, and the submissions received will be circulated to members, then relayed for the administration for a consolidated response to this Bills Committee. Any comments to my proposal? I noticed someone put up their hands. Mr. Dennis Leung. Thank you, Chairman. I agree with the suggested arrangements that we shall invite written submissions from the public, as we're still in a critical phase of the pandemic, in order to expect the scrutiny of this bill so that the employees can enjoy protection under this bill. For reasons of having to self-quarantine so they're getting qualified for sickness leave, I support the written submissions by the public. Next, Mr. Lee Chen-Kung. Well, this is a bill of great urgency. Since we have such advanced technology, especially on balancing the rights of the employee and employees. Therefore, I find it necessary to invite deputations through teleconferencing, which the trade union leaders and the business chambers to speak their minds, to plug in any potential loopholes and to do a better job in promotion. Next, Mr. Lam Chen Xing. Can we turn on the microphone for Mr. Lam? He's not here. Next, Mr. Chao Siu Chung. Oh, we have Mr. Lam back. Let me speak first then. Thank you, Chairman. I support written submissions. I hope that we can use written submissions to consult the public. On one hand, we're still a lot of cases every day, and the intent is to deal with the employee's right during the pandemic. Therefore, I hope that we can pass this bill to afford legal protection for employees. Thank you. Let's turn on the mic for Mr. Lam. I'm sorry for that. Still no sound from you, Mr. Lam. Okay, we got it. Can you hear me now? And thank you, Chairman. I support the Chairman. Since we're still in the grips of the pandemic, that we shall offer the written submissions. And this bill is quite urgent since it's related to the pandemic. As compared to the offsetting of the MPF offsetting, well, since there's still some time for the expiration of this term of government. However, we're dealing with the urgent issue arising from the pandemic. I urge for the early passage, and therefore the public can still express their views through the written submissions. Any other members would like to speak? On the 4th of April, we have received some submissions, and we have already CC'd members. And members feel free to speak your opinion, and we shall continue to accept submissions. And now can we invite the staff to turn to gallery view. And after consulting members, then do not object or put up a notice on the electrical website to invite the public written submissions on their views on this bill. Any objections? All right, none. And now we're moving on to meeting with the administration. With us today, Mr. Chris Sun, Commissioner for Labor, Mr. Mark Kwok-Kun, Acting Assistant Commissioner for Labor, Ms. Francois Lam Seaman, Senior Assistant Law Draftsman, DOJ, and Mr. Anderson Chan, Government Counsel from the DOJ. For the background material, and I urge members to take note at the revised agenda. A, the electrical brief issued by LWB and Labor Department, LD/12-1-1-30/2(c), and the LSC division report on the bill, LC paper number LS12/2022, and C, and the background brief prepared by the Electrical Secretariat, LC paper CB bracket 2192/2022 bracket 06. And on 17th and 28th of March and 1st of April, the Assistant Legal Advisor's letter to the administration. This referred to CB bracket 2192/2022-02 and 04, and the administration replied accordingly. The CB bracket 2192/2022-03 and bracket 01 and bracket 01. That during the class-for-class examination, we can discuss the correspondence between the Assistant Legal Advisor and administration. The Bills Committee will first discuss the policy and issues of this bill for the order and fair arrangement for speakers. I will urge members to remove the hands-off indicators. After clearing the indicators, and I shall invite members to press the wave hand function again. And those interested, please put up your hand. And I invite Mr. Chris Sun, Commissioner for Labor, to walk us through this bill. Thank you, Chairman. And there are three purposes for this bill. First, on the sickness days and sickness allowance. And two, and for any absence from work of employees for compliance with CAF 599. And if they are dismissed for this reason, there's be an unreasonable dismissal. And the employer can request the employees to get vaccinated, and the employees are required to supply the proof. If the employees refuse to vaccinate or show any proof, they will not be regarded as unreasonable dismissal. First, on the sickness days. As all know, the employment ordinance provides a clear framework on sickness days. There are a few conditions to fulfill. First, the staff must be employed under a continuous contract, or they accumulated enough sickness days, for example, working a long enough day to accumulate sickness days. Thirdly, they must be sick leave taken is not less than 4 consecutive days. There are other technical requirements. You need to ensure that they are indeed sick. When we drafted legislation back then, it was normal that you need to provide a doctor as medical certificate. That's quite a reasonable approach. As you can imagine, our original policy intent when employee due to forces beyond their control and unable to report the duty, of course, they need to apply for a sickness leave. And from the experience over the 2 years, we found there are shortcomings. There is an urgent need to expound our policy objective to resolve some technical issues so that we can steer free of controversy. And under Cap 599, there are a few reasons which the employee may have their movement restricted and unable to report to work and call absent first, and he or she may be confirmed or is subject to an isolation order or an isolation or quarantine order is served, or let's say they are absent from work due to a restriction testing declarations. Well, the authority usually stated that you must be quarantined or isolated from when to when. Therefore, we need to amend the EO to expand the definition of sickness leave. Besides a sickness that due to the 599, that the employees' movement were restricted. However, we have excluded a scenario that's a common sense under 599 and sub-slash as C and E applies to arrivals to Hong Kong. For C applies to those arriving from the mainland, and E applies for overseas arrivals. They're subject to quarantine. These two classes are excluded. Well, actually, those people are well aware of the requirements when they arrive in Hong Kong. Therefore, these two classes are excluded, and therefore they cannot claim sickness leave using these quarantine orders. Well, now talk about proof of entitlement. Currently, the medical certificate applies. For Cap 599, the order issued by Department of Health is quite clear. That's necessary to provide additional proof. That so long they can produce this DH proof, they don't need to show a doctor's certificate. But this kind of isolation quarantine order can also be issued through an electronic format besides the physical format. Well, currently employees complain to us of difficulty of showing a physical proof, and these amendments can actually resolve any ambiguities. I emphasize that this round of amendments did not change the major concepts of sickness leave and sickness allowance, just some technical amendments to minimize future disputes. The second amendment, similar to point 1, by relevance, I mean that if an employee due to Cap 599, the movements are restricted, maybe isolation or quarantine order or RTD, and the employees decide to dismiss the employee on this ground, this bill would state that this is unlawful, unreasonable dismissal. And third had to do with vaccinations. As you all know, to fight off the epidemic, vaccination is one of the key pillars. The public and the government has been taking forward these initiatives. The employer can do their part as well. Therefore, under EO, we must state it clear when the employer requests their staff to get vaccinated, and some of the employees refuse to comply, then they will not be regarded as unreasonable dismissal. There are two parts in this. And some of the vaccine requirements is due to the fact that they are subject to administrative control, for example, a restaurant and all kind of specified premises. As they are regulated by Cap 599L, entry to premises, you need to subject to the number of vaccinations and by when. And second, for the vaccine pass, it's not subject to Cap 599L, but rather administrative divisions, for example, LCHEs and so on, which require a vaccine pass and clear requirements of the number of shots by a certain deadline. For this kind of requirement, as one set, another set, even though the vaccine pass may not apply to this premises and employee. However, if the employee hope to cooperate with the government and require the employee to get vaccinated, that we shall cover this as well. However, the employer can only require employees to take one shot at least. Comply with the scenarios outside of vaccine pass. In order to safeguard employee rights, there are also some procedural arrangements. By way of that, first, if the employer makes a request, it must be made in writing and 8 weeks or 56 days notice in advance. And second, we should offer a standard approach. You can't only handpick one employee for vaccination, but exempt others. Either the whole company must get vaccinated, or those employees working as similar staff must be subjected to similar arrangements.
So as to safeguard the rights of the employees. And also in this round of amendments, we've also named some exemptions where the vaccination pass is in existence, then the exemptions will be the same. That is to say, if the employee wants to be exempted, they will have to find a registered medical doctor to show that the employee is not fit for receiving vaccinations. But where the vaccine pass is not applicable, let's say for premises such as ordinary offices, then we have some clear guidelines to talk about why there is examination. For example, pregnant women, during pregnancy, there can be exemption. And for example, it is during the lactation period of the new mother. That is another reason. And then within 6 months of having been confirmed with COVID, that is also another exemption reason. Now, concerning vaccination requirement, because we want to be responding effectively to this wave of COVID, where COVID is no longer a situation in Hong Kong, then we will, the sunset clause will kick in for the last exemption. So for the other two, they are permanent. The first two items, they are permanent. It clarifies what is not clear under the existing EO. Now, Chair, also concerning the commencement date of the amendments, we specify this very clearly in our bill, and that is where there had been 3 readings at the Lecho with the signing of the CE and with the Gazette publication. That will be the day of commencement of this amended EO. Thank you, Chair. Now, for those who want to speak, would you please raise your hand? We have the following 15 members: Lai Tong Kok, Xiao Xiu Chong, Tik Chi Yun, Lee Chen Kang, Lam Chen Sing, Huang Yufeng, Xiu Ka Fei, Lam Chi Yun, Ngan Men Yun, Chan Pui Lang, Chan Siu Hong, Kennedy Wong, Lan Chi Wing, Chan Cho Hang, and Carmen Can have indicated that they want to speak. So 4 minutes each, including Q&A, and we will use the Zoom countdown to calculate the time. And when there are 15 seconds remaining, we will see on the screen the Zoom countdown. And when the time is up, there will be a sound which will be sounded to indicate time's up for the 4 minutes. Lai Tong Kwok first. Thank you, Chair. We have received from the Property Management Federation on the to the Lecho, and exactly they're talking about the last point as mentioned by the administration, and that is in society at large, there is some misunderstanding about the retrospective powers of this amendment to the employment ordinance. And because of Labor Department's notice, some employers feel that this is already a sickness allowance or already a sick leave. Can we please specify or clarify for the employers? That is, isolation orders or quarantine notices or orders right now are not sick leaves. They do not count to that. Please clarify. A second point, with the submission, it says that for contractors, for property management, for government buildings, if the employees, because of COVID confirmation, they need to be treated or be quarantined or isolated, etc., the expenses therefrom, and that is the salaries arising from their not being able to report to work, the government will be responsible for those. And they say that as very SMEs or micro companies, this is unfair if they have to fork out the money for that. What is our response, please? Well, thank you for the questions. Thank you, Chair. First of all, it is true. There is no retrospective powers. It is only after the bill had been passed and gazetted will the bill or the ordinance come into effect. Now, we have also made it clear by the Labor Department at present, I'm talking about at present, under the existing ordinance for confirmed COVID employees with isolation order on hand, the employer, we strongly recommend that they provide a sick leave to them because it is very clear that the employee is a confirmed case. He is sick indeed. And if there should be any dispute, they can come to the Labor Department for resolution. But the order for isolation should be very clear. It does show that the employee is indeed sick, but perhaps a medical certificate from a registered medical doctor is not available. So that's all. But if there's any dispute on this point, please come to the Labor Department. And for the second question, it really applies to property management or security companies. It really depends on the contract signed. For some of the contracts, it is by reimbursement basis, and some are not. So it really depends on the contract terms between the contracting parties. I want to follow up with a question. The isolation order or quarantine order, how are they different? And sick leave, these three are very confusing for the community at large. For example, a person who had to be isolated, would that count as a sick leave if the person has to be absent from work because of that? Can I continue with the answer? Yes, please, go ahead. Yes, for the question, when we are talking about confirmed cases for the employees, and they have therefore to be isolated, but there are some which are not confirmed. There are others, such as they are close contacts of confirmed cases, and they therefore are recipient of quarantine orders. Now, in the existing EO, it does not handle the latter. And before, that is before the amendment of the ordinance, the latter case cannot be dealt with. Charles Xiu-Chong. Yes, thank you. Greetings to the administration. I've heard the first answer from Mr. Sun. I just want to follow up with a question, and that is the existing ordinance for close contact persons. If they are holder of quarantine orders, because they have to comply with the regulations or measures for quarantine, they therefore cannot report to work at the premise of work. And here lies a gray area. But does it mean that the employer does not have responsibilities? And it is because of this that we have this amendment bill. And I think the policy intent from the government is very clear for this amendment, and that is under the fifth wave of COVID, for employees who are complying with regulations, and therefore the movements are restricted, and therefore they cannot report to work, these employees can be given sickness allowance. So this is very clear as policy intent. So Mr. Sun, you just mentioned that there is no retrospective power to this ordinance. So it will start commencement date. It will only come into effect on commencement date. Now, for what I've mentioned as in clarity, or it should be clarified to the community. And also there is no retrospective power, and the policy intent should also be made clear, rather than to elicit another wave of labor dispute, which we of course do not want to see. So Mr. Sun, perhaps you can consider specifying when the commencement date is. Is there a retrospective power, so that, and to what date, so that the affected employees can benefit from this? If you do not do this, how, Mr. Sun, are you able to help those employees or workers who have been affected? Thank you, Chair. Thank you, Mr. Chow, for the question. For the commencement date of the amended EO, it is on normal legal or legislative basis, and that is, there is a commencement date or implementation date of the commencement of the ordinance. If there is to be a retrospective power, it would affect a lot of employees and employers. For those employers and employees who are handling existing cases, they are going about it according to the existing legislation as it stands now, and they are not at fault. But if we are to have retrospective power for the new EO after amendment, it becomes problematic. We look forward after the commencement date. And by such an implementation mode, it would be a lot more ideal. And we have to know that the sickness leave is not a temporary amendment. It is a long-term or permanent amendment, and it would lower the dispute among parties. So I hope that this answer would help Mr. Chow. We have another 20 seconds. Mr. Chow, you want to use up your time? Thank you, Chair. You said that retrospective power would actually make it confusing. I hold the contrary view, and that is, according to the existing ordinance, the employer may have the responsibility to pay for this allowance, sickness allowance. So we need clarification. Yes, Mr. Sun will answer you in the next round. Next, Dick Chi-yun. Thank you, Chair. For this amendment bill, I think the sickness allowance is defined very clearly, and this is good because this will afford better safeguards for the employees and clarity for the employers, so it will minimize confusion. Now, of course, we don't want anybody to fall sick, but the COVID is rampant. And for some organizations or companies, there may be a lot of staff being confirmed and they need to be isolated or quarantined. And this sickness allowance may become a very big monetary sum. Now, if the government is subsidizing this and the government is footing the bill, that's fine. But on the other hand, if the entire service of the company or the organization is affected and they have to hire a lot of the staff in order to provide the same service, that would be a huge amount of expenses. And if at the same time they have to be responsible for the sickness allowance, then that would be great pressure indeed, especially for micro and SMEs. So if there are certain organizations which are small scale, if it causes operation difficulties for them, and of course we do not want them having to go under because of this, can there be an insurance fund which can be open for them to apply for subsidy? Now, this ordinance amendment bill is not passed yet, for those staff or employee who refuse to be vaccinated forms a reason for reasonable dismissal. And there was a Social Welfare Department letter sent to social welfare organizations, subsidized organizations. Anybody wanting to go into the premises of these organizations, they will have to have had vaccination shots. Now, if the staff do not want to be vaccinated and they cannot provide their work or service, and if we dismiss them, causing a dispute, labor dispute, then can we perhaps flexibly handle these cases because we do not want to cause labor dispute? Let's say the flexible measure starting 1st of April, there can be certain space for dispute resolution, some flexibility cut for them, and wait for the commencement of the bill.
Well, the amendment to the sickness days simply complement the shortcomings of the current EO. Well, therefore, it's always the employee's obligation to provide sickness days and sickness allowance, and therefore we not unilaterally change this principle. Well, under the pandemic, some kind of sectors and companies are hit particularly hard. On one hand, the government managed to inject into the anti-epidemic fund and also enhance the arrangement with the employee support scheme. On one hand, the government are helping the companies through the AEF and the price support scheme. Therefore, we should separate the two. We're not talking about the employee ordinance. For the affected companies, the AEF and the ESS are catering for them. That's point one. Second, Mr. Tick had a point. On point three, if the employee requests their staff to get vaccinated, if the employee refuses, and therefore the dismissal would not be considered as unreasonable dismissal. We hope to make it very clear to reduce or minimize the concern of the employers. Under the EO, there's still some room that the employer still had a valid ground to determine. Doesn't mean they are in the wrong. However, if they're in a dispute, they must seek resolution at the labor tribunal. The companies have told us even we're willing to cooperate. If we get to the unfortunate step, let's say the employee refuses to get vaccinated, then I have no choice but to fire them. If the law didn't spell it clear enough that this is not unreasonable dismissal, then must tarnish their reputation or then to the labor tribunal. That's probably doesn't sound right to them. Therefore, this amendment will spell it really clear. Even without amendment, if the employee has reasonable grounds, they are still free to terminate. However, they will need to get a final decision from the labor tribunal under the old word. To reduce labor dispute, let's have some flexibility. If any other questions, let's say for the second round. Next, Mr. Lee Chen Kong. And thank you, Chairman. I noticed that you only accept consultation by submissions only. I hope that with those putting up the invitation notice can also supply some easy info pack on the website to help the employees also do a better job of promotion to invite more views. Just now, the commissioner talked about that this bill is not retrospective. What do we have a sunset clause on this? That once the 599 expire, that this kind of amendments will lapse as well. Some employees have told us we don't know what happened in the future. Well, for those tested positive through RAT, we don't know if they are confirmed or not, or is a false positive. Currently, the DH will conduct sampling checks. Okay, the employers ask the DH for help to do some sampling checks. I know this not going to be for, let's say, have 50% or 30% samples, which the employer can apply the DH to conduct spot checks. Commissioner, thank you, Mr. Lee. For the first question, I already explained earlier, there are 3 amendment items. The sunset provision only applies on the vaccination arrangements that the employer can request their staff to show proof of vaccination to ascertain they're vaccinated. Only this contains a sunset clause. When the Secretary for Food and Health declares the COVID-19 is over, that we're no longer having a pandemic, then the Commissioner for Labor will exercise its powers to repeal these provisions for the sickness leave and for the employee dismissal due to absence from work for compliance with 599. This is permanent. There is no sunset provisions for this. There's a platform for declaring RT positive cases. Currently, these spot check arrangements is very effective. They've done plenty of checks. Let's say you done an RAT, the DH would do a spot check to ensure the results are genuine and to stamp out any false reporting. Let's say some employee claim that request a DH to help spot check the employees, as this has really operating as different mechanism. From my understanding, if an employer, currently there are private contractors, while subject to the agreement, they can actually go door to door to do spot checks with them. This is not a legal requirement though. It's something that must be worked out between both sides. This is doable. The most reliable way is to rely on the DH current spot check mechanism. And through the DH spot check to ensure that the RT tests are genuine and no false reporting. Well, the DH will not tell the result of the spot checks to the employers. I wonder if there can be better transparency, and maybe the employer may not be able to engage contractor to do spot check on the employees either. I hope you can consider. Next, Mr. Lam Chen-Cheng. Thank you, Chairman. But I support this amendment bill and recognized the government's effort of netting a lot of cases in the Kwai Chung estate lockdown. I feel quite ambivalent joining this bills committee. I don't think we need to sit up at BC. The government should have tabled the bill on March the 16th. At this moment, the employees affected by quarantine would have clearly afforded this protection. I know that my colleagues and the public hope to clarify certain areas, therefore we need to scrutinize this bill. This is a good bill for the employees. I'm worried that if there's no retrospectivity, I remember back in SARS, back in 2003, there was an outbreak on March and April. However, on the employee compensation ordinance to include SARS covered by the ECO only happens on the February on 2005. That it was all over by then. Well, there were 0 applications for occupational disease. However, at the time of mostly the employees could not enjoy this protection, I'm worried that this may get criticized by the public. The secretary mentioned that for the employees affected by compulsory testing, even though the law is not clear, however, it doesn't mean that the employer does not mean to take up the corresponding responsibility. I know the employer already approved the sick days. For the bad apples or the non-compliant ones where the government consider paying through the CCF or the ESS. If there's no retrospectivity, how do we deal with the early grievances? Second question, on the vaccination, of course, we encourage the staff to get vaccinated. It seems that the bill has left a back door. If they reasonably believe that the employee, in case of infection, would also infected their staff as well. So this is not, I agree that with this more flexible approach, how do we invoke this exemption, or let's say a valid vaccination request? Let's say there are only two persons in the office and both are wearing masks and quite far apart and don't eat together. Are these exempted and this will not be regarded as a valid vaccination request? During the scrutiny, I hope the employee and employees would have a better idea of where the yardstick is, and there will be less dispute in its implementation. 2 questions. Thank you. Commissioner. Thank you, Mr. Lam. The Secretary said this morning, well, under the prevailing framework, if the staff unable to report to work due to testing, we hope the employees to be a good employer. This requires understanding and sympathy and mutually. Well, under EO, well, that we must pass the bill first before coming have a clear legal basis to provide sickness leave and sickness allowance for employees subject to testing. This is about the both sides and the large number of companies and employees. After amendment, we need to check forward as a proper way, as I explained earlier. Mr. Lam asked about, well, if you take a look at the Schedule 12 on the vaccination request provisions and schedule, let me describe it. The employee must have a reason making a request. For example, they're in contact with other employees or interacting with their customers. And generally, unless this employees always work solo, I couldn't imagine this happening. Well, we should apply the common sense to this. I'm not asking the employer to invoke this. However, if the employer would like to encourage the staff to get vaccinated and respond to government policy, take an extra step to asking all the employees to get vaccinated, there must be a reason. Let's say there are a large number of staff or mixing with each other, or this staff need to interact with other customers and need to protect public safety. And it's really for the good of Hong Kong and for everyone. This is a protective clause. If the employee not need to meeting anyone, and yet you're asking the staff to vaccinate, then they may object that I'm not required to interact with anyone. Therefore, whether I'm vaccinated or not, there should make any difference. Therefore, I can't say that whether they are compliant or not in this hypothetical circumstances. Next, Ms. Doreen Kong. Chairman, I support passing this bill as soon as possible, especially for sickness days. This bill can clearly delineate the definition and reduce the dispute between both sides. And 32 KB in this bill for the vaccination requests. I've checked on the bill as we compare the common law jurisdictions on the commentary on the vaccine mandate in those countries, may I ask the DOJ or the commissioner first, under 32KB of the bill, would be in violation of the discrimination ordinance, especially the disability discrimination ordinance. I'm a bit concerned about this. Even though the relevant provisions is linked to the 599, okay, however, the 32KB not restrict to certain professions. What the scope or applicability is very broad. I try to consider from the devil's advocate point of view, if the government would not dare to introduce a legal vaccine mandate, why could the employees do so?
For the legal drafters, can I ask you, in common law countries, are there precedents? Are there any similar legislation, please? And the third question, now, if the employers request the employees to take vaccination shots, if the employees sustain any medical incidents or mishaps, what is the liability? Of course, we want to encourage the people of Hong Kong to take vaccinations. But on the other hand, we don't want SME employers, because of 32KB, asking the employees to take vaccination shots, therefore sustaining any liability or results. Can there be written response to my questions first, after answering the questions here? Mr. Sun or Ms. Chan, anybody? Or would Mr. Chan be answering the question? Thank you, Ms. Doreen Kong, for the question. Concerning 32KB, it is about the employer who can issue a notice to the employee to take vaccination shots. So this is not empowering the employer to say that the shot is mandatory for the employee. But where the employer had issued this notice to the employee, and if the employee is not coming under the exemption categories, that is lactating or pregnant women, etc. And after 56 days, if the employer dismisses the employee, only then will it be construed as a non-unreasonable dismissal. So this is not empowering the employer directly to request for vaccination shot. So technically, this is different from the government in requesting the citizens of the country or the territory in taking vaccination shots. And the employers have the right to decide what to do. And whether there are precedents in common law countries and jurisdictions, I will have to find out before I can respond to that question. But again, I just want to say this is not giving the employer the right or the power to force the employee to take vaccination shots. As for medical incidents after taking vaccination shots, because this is about the contract between the employer and the employee, I will go back and look at the to find out the background information. This is a relationship between the employer and the employee, and our ordinance had not dealt with that part. Yes, and Ms. Doreen Kwong had asked whether there is any discrimination under the discrimination conventions or ordinances. Can you provide written response on that as well? Yes, we will do that. Shu Ka-fai next. Thank you, Chair. First point, I would want to say that in the industry, a lot of employers are saying that for the employers to handle confirmed cases among employees, they are fine with that. That is to say, if employees unfortunately fall sick under COVID and the employers are responsible for their sick leave, that is fine. They find it acceptable. But for the rapid tests bought from the general market, how can we ascertain that indeed those test results are reliable, that the employers are not being taken for a ride by the employees. Now, also, where the employees' family members are confirmed cases, let's say for the first day, it is the parent living in the same premise home that is a confirmed case, and then on the 7th day, the employee himself, and then the sister falls ill, and then it carries on for 28 days, and the employee is still a close contact, and the employers will have to be responsible for a whole month of pay for the employee. So the employers, business owners are really under a lot of pressure already. Can there be some relief for them, please, given the situation? Thank you for Mr. Xiu's question. Self-tests, if it is a positive result, at present, there will have to be registration on the government platform. You cannot just take a picture saying that there are 2 red lines and send it to the employer, and therefore it is a confirmed case. You cannot do that. But rather, the employee will have to upload onto the registration platform. And as mentioned, the health department has a very stringent measure against any false declaration, and they do spot checks on those registrations. And perhaps the employee will have to consider results. The results are not light at all, and they may be asked to go to do the nuclei tests by the government, and they will have to consider whether it is worthwhile for them to falsely declare themselves falling sick of COVID. And we want to be able to minimize such cases of false report. And the second question raised by Mr. Xiu is that there are certain families which the family members may take turns in being confirmed for COVID, and it affects everybody's livelihood. And indeed, there are some small business owners who have made the same reflection. They are already under pressure in their operation or business. And if there are confirmed cases among employees, it's not just about providing the sick leave, but also they will have to find substitutes for those sick employees. So that's business or economic pressure for them. Where the employers have to foot the bill for sick leave, that has always been the case. That's always been the framework, and we understand that. But for COVID situation, a lot of industries and business are under dire pressure. We know that. And the measures from the government is the ESS, the Employment Protection Scheme, and also the community care scheme, etc. So these are separate. So under the ordinance for employment, this should be dealt with on its own. And where there are dire situations because of COVID, then under the anti-epidemic fund and also ESS, those should be activated. Well, Chair, I understand. And yes, indeed, the funds can help the companies, including the anti-epidemic fund. There's an $8,000 cap subsidy, but some industries are not included in the scheme. Let's say for the cleansing companies, if many of their staff members have fallen sick and they have to find substitutes for these staff members, it is a huge outlay for these cleansing companies. Can you please think about that as well? Thank you, Chair. Now, this quarantine order is 14 days, and that may change. And on the 6th day, if they do a rapid test, and if it's negative on the 7th day, they do another test and it's negative, then the isolation order would be cancelled. And is that true? Then the for this amendment bill, is it true that the sick leave would also be cancelled after testing negative, as mentioned just now? Now, for where it is not coming under 599L, and not under the government policy where the employer requests the employees to take vaccination shots outside of the exempted persons, and that is for pregnant women. For pregnant women and for lactating mothers, actually, the vaccinations would provide extra layer of protection for the mothers, the person, and also for the babies as well, and the fetus as well. So by amending the bill and by your framing of the amendment, it may imply that you think that the vaccination shots are detrimental to the health of the mothers and to the fetus and the babies, and that may be wrong. What is your response, please? The line is broken. The line is broken. We do not hear Mr. Sun's response. Problem with the connection. Can you repeat yourself? We didn't hear you. Well, thank you, Mr. Lam. Thank you, Chair. Concerning the first point of the amendment bill, for quarantine order, isolation order, we link it with the health department's quarantine and isolation orders. We will not, in our ordinance, specify the content of the ordinance or of the order, because the origin of that power comes from Cap 599. And it is true on the 6th or the 7th day, if the self-tests are negative, then the order would be cancelled. So where the order is cancelled, yes, the leave, the sick leave would also come to a stop, because that is the origin. The 599 is the origin of this requirement. So that is, the logic is very clear. Now, for your second point, yes, pregnant women and lactating women should also go for vaccination because it affords extra protection for them and also for their babies and fetus. But there are 3 exemptions, and that is pregnant mothers and also lactating women and also 6 months after COVID confirmation. The reason is that in a general situation, to provide this power to the employers, at the same time, we should take into account the concerns of the employees so that the employees can have a choice, even though we all know that pregnant women should go for vaccination, but for whatever reason, they do not want to do so. We think it is only reasonable that we provide that space for them if they, for whatever reason, do not want to go for vaccination while they are pregnant. And they should have that recourse, that choice provided to them. And therefore, we have put in this exemption. As long as they meet these exemptions, we find it acceptable. But again, I want to reiterate that we follow science. We do encourage pregnant women and lactating women to go for vaccination. Next, Mr. Ngan. Yeah. The government is repeating itself and saying that employees do not need a medical certificate. As long as they have the isolation order and the medical or the confirmed COVID case status, then they should be entitled to sick leave. I want to find out from you how many of such cases have there been where the employees had not been able to claim sick leave, even though they have the requisite items. How many cases altogether? And how many cases have gone to the Labor Department for help? And also, for close contact, there is no protection for them. Has the government considered helping the employers who will therefore be able to, or subsidize the employers so that they are able to provide the subsidies or the allowance to the employees? Now, in answer to the question, Before the amendment, if you are a close contact and you only have a quarantine order, you are not entitled to sick allowance or sickness allowance. But as I've mentioned just now, under the anti-epidemic fund, the government is doing a lot of things, helping individuals, employees, and also employers. So the affected persons, they can go via that channel to obtain government help and subsidy. That would be more reasonable because we want to be able to allocate the resources correctly. As for the second question, Mr. Ma, well, thank you for the question. Thank you, Chair. Now, for confirmed cases of employees with the isolation order, the Labor Department had actually received inquiries concerning these. We do not have detailed information as to how many cases there had been, but when the COVID situation was dire earlier, we had received employers and employees inquiries as to what they should do. And our recommendation to them is exactly what we have put up on the website of our department, and that is telling them that isolation orders for confirmed cases among employees, the employer do not need to request for a sick leave certificate in granting sickness leave to them. And where there are disputes between employer and employee, we are very happy to step in to help them resolve that. And on the telephone, we have helped a lot of employees and employers in clarifying the situation to them. But coming to the Labor Department or going to court for judgments, so far we have seen none, but rather providing the Labor Department providing third-party opinion, the employer and employers have been able to resolve the problems. But if there are specific situations where the employer really need to request a medical certificate, we will follow up as to why they indeed need to do so.
And a follow-up, Mr. Nguyen. First, well, the Labor Department did not keep any statistics for inquiries. I was quite disappointed. This is very important. We shouldn't rely on the AEF to support those living from hand to mouth. Thank you. So the Labor Department, I hope you can collect some statistics. Next, Mr. Chen Pui Leong. Thank you, Chairman. First, I welcome the amendments to the EO. It clearly defines that the definition of sickness leave due to absence from work for complying with the CAF 599 requirements. And we also are in line with the objective of protecting public health. I have one question. Even though the government claims that if the daily caseload is reduced to a certain level down, it will kickstart the universal compulsory testing. If this exercise is to take place, let's say if it lasts more than 4 days, let's say this having a district lockdowns, that means all the employees or employees will be affected by this compulsory testing. And the employees are entitled to the paid sick days. They might go against the legislative intent. Well, this bill cover some stuff. Does that mean now in this case that I would need to provide sick leave or sickness allowance to all the employees in the companies? I wonder if you should introduce some exemptions. Second, this bill is quite broad. I know we need to have some flexibility. In terms of execution, there are a lot of ambiguities. I hope that the LD can come up with the implementation guidelines to deter any future disputes. Commissioner, thank you, Chairman, and Mr. Chen. Well, we can't answer the question. There will be a universal mandatory testing for this amendment bill. we make some assumptions. We don't know that if the testing go ahead, and we don't know what's the legal basis for that. Let's say they decide to introduce a compulsory testing declaration applying to everyone in Hong Kong. Then this bill will cover the CTNs. Let's say the restriction on movement lasts more than 4 days, that it will be in line of the amended definition of sickness days. However, I don't know what the eventual arrangement will be. What if we can plan ahead, as it may happen? We can only offer it within the existing 599 provisions. I can incorporate provisions not in the 599. However, we still have some built-in flexibility. However, Schedule 11 will contain all the provisions. Let's say there are new requirements in the CAT 599 and will restrict movement. Well, we can just amend the schedule. The commissioner can just amend the schedule through subsidiary legislation to cope with any new arrangements under 599. We try to cater for every imaginable scenario. Well, this is a hypothetical question. In terms of the burden, that's another question. This bill deals with the eligibility of sickness days and also have some flexibility. Second, for the implementation, we need to issue guidelines or some FAQ. Thank you for your suggestion. Thank you, Chairman and Mr. Chan. Thank you, Commissioner. Next, Mr. Chen Siu Hong. Thank you, Chairman. First, I'd like to thank the Commissioner. A few days ago, he arranged a few colleagues for a briefing, and he managed to clarify a few issues in this bill. I agree that we not only need to offer better protection for employees' rights, but also clearly define the employer's obligation. I support the Employment Amendment Bill 2022 to deal with the fallout from the pandemic and also address the disputes or labor disputes. I heard different aspirations from employee and employees, and the members from the labor and the business sector have expressed their views. I will not repeat them here. I have a few questions for the Commissioner. First, similar to Mr. Yan, since the start of the fifth wave, how many inquiries the Labor Department received due to labor dispute arising from COVID-19? And how many dismissal due to absence from work for complying with the 599? I was disappointed with the Labor Department. I'm worried about the friction brought by the pandemic. Like, I hope that the department can provide some statistics after the meeting. Second question. The amendment bill involved isolation and quarantine order. Ensure the patients to comply with the orders. There's clear examples of sickness days. However, the close contact subject to quarantine orders have the movement restricted. For example, they can't go out for work. Well, they're not confirmed cases and yet counted as a sickness days. I hope that department can expound the legal perspective. And thirdly, even though the government has suspended the universal compulsory testing, just now Mr. Chen mentioned, shouldn't we be prepared ahead? The government also encouraging the public to conduct RATs and upload the results to the declaration platform. However, this bill is being debated. Before this bill is passed, how can the government deal with the any potential disputes. There could be a large number of cases netted by the voluntary RT exercise. First, on the statistics, you need to include the number of dismissal. As some members received some complaints, I hope that the LD have compiled statistics on the number of dismissal. Can you start from question 2, please, Commissioner? Thank you, Mr. Chan. That under this, the new EO, that we expand the definition of sickness days, besides being sick with doctor's certificate, that under 599, the movement restrictions is also applicable. And this only covered the confirmed cases, isolation orders. The close contact serving quarantine orders are also eligible. You would say that this is not their own making. This is not something they can control. They couldn't go to work. That's no different from them being sick. So under EO, this amendment is the quickest way to respond to the situation of any potential ambiguities, or delineating the obligation and responsibility of both sides. So, and we also need to separate the two. In the context of combating epidemic, we need to roll a lot of things quickly. The amendment to the EO hopes that we hope to provide a legal basis for the employer requests to vaccinate. Of course, we need to deliberate and pass the bill to enact this. When the government had distributed over 3 million anti-epidemic service kits with 20 RTs, and this RTs can help us to control the pandemic. We don't need to start the RTE exercise after the bill is passed. I know that under the prevailing law, for any quarantine or isolation orders, we hope that both sides can be understanding to each other. If there is any dispute, the prevailing approach that if both sides could not come to agreement, the Labor Department can mediate. We will do our utmost within the prevailing framework to control the pandemic. Thank you. Next, Mr. Kennedy Wong. Thank you, Chairman. The Commissioner explained very clearly. Just now, a lot of the colleagues have spoken before me on safeguarding labor rights. The DAB agree with the general direction. However, the DAB Business Commerce Panel have met a lot of the SME representatives, and including my own import-export sector of the dozens or so trade associations. A lot of the trade associations met about over 80% of the SMEs. Their reaction was similar. If any staff was unfortunately is actually infected, whether for 14 days or any days of sickness, they see this as a right thing to do. However, under Cap 599, let's say some of the staff is not infected, but just close contacts, or the family members of the close contacts. In early January, some of the colleagues took part in a gathering, and some attendees were sent to Penny's Bay. Then I was made aware that the attendees might be regarded as the close contacts of confirmed cases. When they returned home, an 88-year-old woman was hauled into Penny Bays for 4 days. Under Cap 599, the definition of close contacts is quite broad. and subject to the change of the pandemic, there may be revisions. From the employee's perspective, especially the SMEs, should the SMEs bear the full cost of this amendment, even though the government mentioned AF and the employment support scheme? How this is all one-off measures. Each time we need to urge the government to make further revisions or amendments. Therefore, not all the close contacts are eligible for government support. I urge the Bureau and the department to holistically consider that while trying to push for the bill's passage, you must cater to the SMEs. Let's say the employees are close contacts, and so the cost arisen from the isolation, or the isolation must be borne by the government. Thank you, Chairman and Mr. Wong. Mr. Wong has met a lot of SMEs and heard their opinions.
I'm very thankful that you have met with so many SME business owners and have reflected their views to us. And we fully understand in our contacts with them that they have their concerns. But still, under employment ordinance, the intent of the ordinance has always been that sick leave is a responsibility of the employers, but it is just because of Cap 599 that we have made some amendments this round. And in making the amendments, we have to think about the following, and that is, of course, the COVID cases employees will need to be isolated, and their close contacts as well, because they may very well turn into confirmed cases, these close contact persons. Otherwise, they will be posing a threat to society. You cannot say that for close contacts, we will treat them differently under the employment ordinance. From public health point of view and for safety of the individual's point of view, we should treat them the same, close contacts as well as confirmed COVID cases. But I think it's not just sick leave that the companies are thinking about. Under the COVID situation, there's a high chance that the employees may turn into confirmed cases or close contact cases. So every time there's a wave of COVID, we are responding to the situation. As well, the ESS and also the anti-epidemic fund. Of course, the anti-epidemic fund, for example, there have been different rounds of it. The government have been responding to the COVID waves, but we should separate the understanding of the two. Employment ordinance, we have to be clear about its role and also its intent, and to lower the incidence of disputes. And for the other side, that is subsidy to the employers and business owners, that will have to come from the anti-epidemic funds and other government funding and measures. So I know this may not be completely comprehensive, but on the other hand, we have to look at the different channels in order to combat and respond to the social issues engendered by the COVID. Thank you, Chair. Now, in the epidemic time, Kwai Chung Estate, because it had come under a quarantine order, a lot of employees or residents in that estate had been affected as employees. For some residents, or even residents who are not under the quarantine blocks, their employers have singled them out. And at the time, the FTU had suggested that quarantine orders as well as isolation orders should be construed as reasons for sick leave allowance. So I'm thankful this time, I'm grateful to see that this is enshrined in this round of the amendment. and the Labor Department have recognized quarantine order and isolation orders both as sick leave, and that is helpful to the employees, and it is good. Now, perhaps the commissioner can answer a question, and that is employers and employees both feel that there are more sick leave granted to employees, or employers think so. Can you please clarify that this ordinance by its amendment had not increased the number of sick leave? In fact, the employees will still have to use their accumulated sick leave to apply for these sick leave under COVID. Now, for Kwai Chung estate situation, there had been certain residents who are outside of the blockaded blocks, but the employers still forbid them to report to work. For such persons, like the residents who are living in the estate but not in the blockaded blocks, can the Labor Department help them? So these persons in similar situations can also be entitled to sick leave. A lot of employees are asking this question. A third question, for the quarantine and the isolation orders, they are 24 days in duration. Now, if an employee had taken 2 vaccination shots and on the 6th and the 7th day consecutively, if they do the self-test with negative results, then they will be able to have free movement, including reporting to work. Now, the quarantine and the isolation orders are both 14 days in duration. Does it mean that the employees can take 7 days or 6 days sickness leave given that they have the negative test results on the 6 and 7 days? Because let's say they do not have sufficient accumulated sick leave. Can they do that under that circumstance? Another question, and that is applying for the quarantine and isolation orders take time. Can it be that where employees can provide the proof, they can be entitled to the sickness leave? Or can the Labor Department or some department help with these situations? Well, thank you for the questions. And Chair, yes, indeed, it is true that this amendment bill is based on the existing legislative foundation. And that is, there should be continued employment and the employee should have accumulated sufficient sick leave days. And what does the latter mean? Under the employment ordinance for first-year employee, that he will be entitled to 2 holiday days every year of work. And then it goes on. It will accumulate as years go by. And the sick leave days will have to be accumulated sufficiently. And these accumulated days will have to be consecutively for 4 days or more in order to be eligible. So in that sense, with this amendment bill, there is no extra burden on the employers, because the max is still 120 days, and it is still on the basis of the accumulated sickness days. But of course, employers may be concerned and worried because there'll be more people falling sick, more employees of theirs falling sick, and it causes a burden for their operation. But on the other hand, for the ordinance, we have just clarified the intent. We have not added any new burden to the employer. Now, another point, responding to Mr. Leung's question, on the 6th and 7th day of after the with rapid testing and the results are negative, then yes, the person can report to work as soon as possible. And of course, sick leave only attracts certain payment, while reporting to work, the employee is given full pay. There is a difference. So under Cap 599, whatever the orders are, quarantine or isolation, it basically just follows these orders. So if the orders have been cancelled and been removed, then of course the leave can also be, or sickness leave entitlement would be removed, because a person will be able to report back to work. Right. As for the third question, Mr. Ma will answer that question. And another point, the employers are worried, even without the quarantine or isolation order, the employees should not report to work. Now, this is not right because the orders are scientifically based and they are stringent. If the health department feels that there need not be a quarantine order or isolation order, then the employer should not forbid the employee from reporting to work. Mr. Ma? Thank you, Commissioner. Concerning the quarantine and isolation order, when do they need to be handed to the employer to entitle for the sickness leave? There is no requirement under the law, and that is they can have the proof, and if they comply with the requirement, then the employer can, in the next payment of salary, also pay out the sickness allowance. So can these be provided, these information or evidence be provided afterwards? Yes. But where the employer is in the know that the employee is the recipient of the orders, then they should, even without seeing the orders, the employer should be giving out the sickness allowance and the sickness leave. Sunny Tan, thank you, Chair. I just want to clarify on behalf of the industrialists and the employers. Just now it's been said that the burden is not even is not higher for the employers with this amendment. Well, because accumulated leave can be can remain. That is to say, they need not be taken in full. What I want to say is that for the industry and commercial sector, because of COVID, they have provided a lot of support to the employees. And we should remember that they have given these extra efforts to the employees. I'm not against the amendment, but from the industrial and commercial sector, while we protect the interests of the employees, we should also protect the employers' rights. Now, Mr. Shukafai had mentioned just now, we notice that in the community, there are people circulating ways of falsely providing positive self-test results, how that can be done. I hope that the government can very sternly gatekeep the entire process. I heard the commissioner in saying that in order to obtain the qualification, they will have to register the test results on the platform. That is what I remember him saying. And I think this is very important. And only that can there be effective monitoring and tracking. And we want to see that the confirmed employee, after he can come back to work, we can check, the employer can check his records, whether he has, the employer can look at his leave home safe records to see where he has been to. Well, I mean, in the past week, it should be 0. He should have been to no other place except from his home. So the employer should be able to check that. And also to empower the employer to conduct antigen tests before and after reporting to work for the once confirmed employee. This is to lower contagion, to lower infection, and also to provide proof to the employer. And another point, there have been more stringent measures against false claims of cases. Of course, we don't want to see any false claims, but we have to review the penalties. And if we can make the penalties heavier, then I think it will save all of us a lot of work. I wonder what is the response from the administration, from the commissioner. Commissioner, Thank you, Chair. Thank you, Mr. Chan, for the answers. Yes, Mr. Chan had spoken on behalf of the sectors, of the industries and commerce, and I know that almost all employers are conscientious employers, and they want to be helpful. And for that, we are very grateful, whether to employers and employees. Otherwise, the Labor Department will hardly be able to function without that goodwill. Now, for gatekeeping, it is the health department that does the gatekeeping, not the Labor Department, but they are stringent as far as I know. And also for the test results, for rapid testing, they will have to be uploaded to the platform. And after that, they will get a quarantine or an isolation order. And only getting that order can they come to apply for sick leave. They cannot just take a picture of the self-test kit and say that, oh, I'm entitled to sick leave. Well, I hope that this is clear in explaining to Mr. Chan. Now, Mr. Chan asked whether the employers can check the Leave Home Safe records of the employees. I cannot answer you that question. I can go back and ask. Because after all, the mobile phone belongs to the employee. Can the employer actually do that? I think we will give you a written response after that, because today I dare not give you an answer.
As for whether we should require RIT before going to work, that something is subject to mutual agreement. I'm happy to do it myself. I hope that we can handle it better, especially if it's not expensive and mutually beneficial. I think it should be promoted. And for the last point, whether we can toughen the penalty, I can relate to the health authorities as beyond the scope of this bill. I understand your concern. Hope that we should abide by the anti-epidemic regulations and should not breach them casually. Thank you, Chairman. Next, Ms. Carmen Can. Thank you, Chairman. Hi, Commissioner. Signing up for the BC, well, requires some effort. Well, this demonstrates the members' concern that under the epidemic to comply with the emergency regulations, the citizens' movement are restricted, and how to strike a balance between fighting the epidemic while dealing with the labor relations. Commissioner, the object of this bill require come up with a dummies pack from a layman perspective of why we need to amend this bill. When will it take effect? Some members asked that this bill is not retrospective and must be commenced through Gazetted. I hope that we can pass this bill after achieving consensus so that the affected employees and the employers are knowledgeable. And the execution is of the absence and to prevent any future labor disputes. And what will be changed must be expounded clearly. I know that there will be 3 amendments that for the sickness days, that schedule 11 part 1, there are 3 scenarios. First, while confirmed cases subject to isolation order. For close contact and other reasons, you're subject to a quarantine order that will be covered. And for the compulsory testing, as for compulsory declaration, compulsory testing order, or RTDs, there are also some exemptions. The lockdown must last more than 4 days to meet the bill's criteria. Then how do both sides comply with it? Okay, connection resumed. we need to refine. Let's say if they're tested negative, the isolation or the quarantine order will be shortened. For all these kind of scenarios, that must all be explained in the guide for dummies. Hope that before the next meeting, we can have a presentation for us to comment. And this dummies pack will be distributed to both sides. And second, on the question of vaccine pass, I hope that the commissioner can elaborate. Just now heard from you that for the pregnant and the lactating employees, we are exempting them. For the vaccine pass would not apply to the pregnant and the lactating employees. Of the vaccine pass well, let's say for those covered for a vaccine pass due to a medical reason or a place where the vaccine pass applied, let's say passing a shopping center onto a workplace, then it would not apply to them. You need to explain this clearly. Maybe a commissioner can spend some time to explain the exemption of vaccine pass on pregnant and lactating employees. Thank you. Commissioner, please. Thank you, Ms. Kan. Well, for the guide for dummies, we'll compile it. And before the next meeting, I will circulate to members. So we can sum up the bill's objective in very simple terms. Second, we'll talk about exam scenarios of vaccine pass. Let's say it's not a specified premise. Let's say just a normal office space, and not a beauty parlor or a restaurant, or not an RCHE. Therefore, the vaccine pass don't apply. For this amendment bill, for the places where the vaccine pass is not applicable, where the employers would like their staff to get vaccinated to help fight the epidemic, therefore they would have the right to make such written requests that the employees are required to show proof within 56 days of receiving at least one shot. For this, if you're pregnant or lactating, or you're already a confirmed case within the first 6 months after infection, then you would be away from the requirement to show vaccination proof. A lot of employees were worried about this scenarios outside the vaccine pass. Therefore, they hope to have more flexible arrangements, especially for the pregnant or lactating women due to various kind of reasons. In my response to Dr. Lam, you understand that everyone should get vaccinated medically. However, we understand in labor's concerns. Well, for the scenarios not covered by the vaccine pass, we have a clear exemption regime that will be the right thing to do. Therefore, we will make it clear that if you're pregnant or you're lactating, that you need to show the proof of vaccination. And this requirement does not apply to them. That's somewhat a compromise. Consider the balance of powers. Thank you. And that's the end of the first round. I hope I will share some observations with the commissioner. In terms of publicity, I hope that we can invite public submissions. Well, in reality, it seems that employee or the employees are not familiar with this bill. I hope that the commissioner can prepare some guide for dummies or even more simple materials. Let's say it's scenario 1, 2, or 3 for public understanding. I also observed that some business or professions like security guards, estate management companies are suffering a double blow. First, the need to pay the sickness allowance to the employees, and then also need to hire workers to cover the sick workers. In terms of the ESS or the AEF, whether there will be some supplementary measures. They note that the AEF has lapsed and the ESS probably may not able to help them. I hope that we can express this opinion. Well, now that they know that it's not retrospective, maybe in terms of publicity, or at least include more industries. We hope to strike a balance. For example, some members were concerned that even for the quarantine order, we need to strike a balance on the definition of close context. Let's say, what if someone get infected after 7 days, and they will need to take additional leave, and there will be a huge undertaking from the employer. I hope that the department can strike a balance. If members would like to have a second round, please put up your hand. Let's have 3 minutes per member, Q&A included. Where's Mr. Lai Tongguok? Mr. Lai? Thank you. Even though there are 3 objects of this bill, however, it's actually complicated to execute, not only involving the employee and employees. Maybe there's something we haven't considered. Well, we're also employee and employees in the context of foreign domestic helpers. We are the employers to the FDH. I suggest for the Labor Department, but when you enact this legislation, you must provide an easy to understand a brief introduction. Just put it up online. You also need to conduct a publicity, let's say with the common Q&As, to achieve better public understanding. You need to be more than bilingual. You also need to include the popular FDH languages. Otherwise, a lot of middle-class employees will be in trouble. That's point 1. Point 2, just now the commissioner said that the Schedule 12 can be amended at any time to cope with new contingencies. However, this amendment will have huge ramifications. For example, the sickness state are not covered quarantine orders, but in the future it will. For example, this slight amendment would have a huge ripple effect. Can the commissioner promise us that if we need to amend the schedule, that at least you will consult the LegCo? Amending the subsidiary legislation is also a negative vetting. Thirdly, this bill is very important to both sides and the society as a whole. However, I disagree with the commission understanding of the sickness days. Well, we change the definition of sickness days. To a certain extent, you are providing stronger safeguards for them. However, to the SMNE's bosses, due to this amendment bill, especially for the labor-intensive companies, let's say most of the cash flow is spent on payrolls. This will create a huge problem for them. I hope the government can work with different bureaus that, let's say, within the AEF supplementary measures, must provide a certain extent of subsidy to this greatly hit employer so they can survive. Thank you. Brief response, please, Commissioner. Thank you, Mr. Lai. Thanks for Mr. Lai's reminder. Yes, so and when you hired FDH, you are an employee yourself, and therefore they are subject to protection by this bill. In our introduction, We'll also translate it into various kind of the usual kind of foreign languages. We need to amend Schedule 11. It will take the subsidiary legislation route. We must consult LegCo. And finally, yes, like the chairman reminded us, the connection is lost. Connection is lost. Interpreter can't hear from speaker. Screen frozen. Please continue. I'm actually done. Just now, we lost your feed. Oh, please repeat. Mr. Lee Chen-kung.
Can you hear me? Yes, we can. Thank you. Thank you, Chair. First of all, on the fact sheet or facts at one glance, a lot of members have talked about that, and Lai Tong Kwok was saying, our colleague was saying that it should be provided in different languages so as to facilitate employees of different nationalities. This is necessary because Hong Kong is a diversified community, and also it will help resolve some of the questions between employers and employees. And just now it's been explained to us by the commissioner that 2 of the changes or amendments will not have sunset clauses, so they will be permanent. Now, concerning SME companies and their burden in facing situations where the employees are COVID hit and they are taking sick leave and they have to provide for the sick leave allowance, and at the same time they have to find replacements, and these replacement staff are not easy to come by or cheap to come by. So given that, would the government be considering where they can put some skin in, let's say subsidize these employers as much as possible? Would the commissioner please go back and consider that? Second point, for the amendment bill, there's a conundrum, and that is about close contact. What is a close contact? Commissioner, in your amendment bill and the ordinance, would you please specify very clearly, would a person eating at the same table as a confirmed case or being in the same meeting room as a confirmed case, would these persons become close contacts? Because there are grave ramifications. Let's say working in the same office, people are going face to face in their work situation already. If there is one confirmed case in that office and everybody is a close contact and they will have to be quarantined, what happens then? So if the commissioner please talk to the health department as to what constitutes close contact, and then tell the employers and employees accordingly. Commissioner, any response, please? Yes, a quick response. Yes, a fact sheet we will provide for that. As to the SMEs burdens, yes, as the chairman had mentioned, yes, we will be responding to that. And thirdly, close contact is not defined by the Labor Department. It is not governed by this amendment bill either. It is the Health Department which determines that. Mr. Lee, if you want to know more, perhaps we can provide to you some latest information from the Health Department, because according to scientific knowledge, evolvement of the COVID situation, the definition is also changing as well for close contact. But perhaps I can go to the Health Department to get that latest definition for you, Mr. Lee. Next, Ms. Kong. Thank you, Chair. Just a simple question for the Commissioner concerning spot checks. I saw that a number of my colleagues, members, are concerned about that point, false reporting of positive case. Now, in the amendment bill, where does it mention this? And that is, let's say in the future, should there be spot checks from the Health Department and a false declaration is filed, and because this is afterwards, after the effect, would it say that the employee would not be entitled to the sick leave. Now, let's say the employee had already received the sick leave, and does it say in the ordinance that the employee is not entitled to that, but given that had already been granted, will there have to be some compensation given from the employee to the employer, or where there is a violation of the order of the quarantine or isolation order, would the employer know about it? Well, I'm worried that the department is very hardworking, putting in efforts in spot checking, but the employer would not know. Under 599, where does it say that the employer would know? Thank you. Thank you, Chair. Thank you, Ms. Kong, for the question. For spot checking and uploading to the registration platform, that is a responsibility and work of the health department. And as far as I know, they're very stringent in that work. And if it is found that there had been false registration or declaration, let's say if it is actually a false positive, that is a person is no longer should not be construed or qualify as a quarantined or isolated person. Actually, Mr. Ma can explain that situation. Now, actually, where there is a situation where the employee lies to the employer and falsely asks for or applies for sick leave, even though he knowingly knows that he is not a holder of a order, quarantine or isolation. So it is a false declaration. What then? Mr. Ma will answer those questions. First of all, the scenario where under spot check, the employee is found to have registered a false positive claim on the platform, then the person should not be entitled to any order, or the order should no longer be applicable. Then under the amended ordinance scenario, he would not meet the requirement, and therefore this employee would not have the right to sickness allowance or sickness leave. And the question was, what if that had already been given to the employee? Well, the employee, if he is not entitled to the sickness allowance, it's like paying, overly paying by the employer to the employee of salaries. And in that case, there should be repatriation of the overpaid sum to the employer. Otherwise, the employer can pursue. Now, when the employee wants to get certain benefits by falsely declaring positive test result, it would be the same as providing a false sick leave or sickness proof to the employer. So that is the same treatment in such situation as providing false, falsifying sickness proof to the employer. All right, we have two more members. First of all, Mr. Leung Chee-ing, and then Leung Chun-sing, and then I'll draw the line. Thank you, Chair. The FTU had received over 300 cases asking for help concerning quarantine and isolation orders cancellation. The situation is not ideal. We get a number of cases where the employers know the situation and they're waiting for the amendment bill to go through before they construe these orders of quarantine and isolation as sickness allowance and sickness leave. But I know the employees are hardworking and employers are conscientious, but on the other hand, the employees now really do need the sickness allowance and sickness leave. Now, we also know that in complying with Cap 599, if the employer had dismissed the employee, this is unreasonable dismissal. And most of the employees actually just want their job back. Can the Labor Department help them? If in the future they meet with unreasonable dismissal situation, can you help them get their jobs back? Even though they are entitled to allowance, but really what they're after, what they want is a job. Can the Labor Department help them? And another question concerning sunset clause on vaccination. Now, we thought that many people think that the sunset clause is applicable to all three items. And now we hear that it is only applicable to the vaccine pass. So if there should be another wave of COVID, would this vaccine pass item get a sunrise again, be applicable again? Thank you, Mr. Leung, for the question. Thank you, Chair. For the first question, Mr. Ma will answer that question. For the second answer, it is true. Let me just say this very clearly. The sunset clause is only applicable to the vaccination item. For sick leave and also unreasonable dismissal, those two are permanent. Now, why? Because the vaccination refers only to COVID-19 vaccination, and where there is no COVID-19 situation, the vaccination for COVID-19 should also be cancelled, and therefore the sunset clause. Mr. Ma? Thank you, Mr. Commissioner. For unreasonable dismissal, it is already in the existing ordinance. If the employee fulfills certain criteria, and if the employer, because the employee is complying with Cap 599 and misses work and therefore is dismissed by the employer, this constitutes an unreasonable dismissal. According to the existing prevailing law, the employee can request for compensation and also request for a rehiring or recovery of the job. But of course, the labor tribunal will have to adjudicate on the latter. This is already enshrined in the existing law, and in protecting the employees to say that this is not a proper reason for dismissal, there is already a recourse for employees for reinstating the job and for compensation. Lam Chen Sing. Chair, thank you. Now, if this ordinance after amendment comes to pass, I hope the Labor Department will do the relevant ancillary work. The Manpower Panel had mentioned that last year for Penny Bay residents, there had been a issuance of registered medical doctor certificate, but not so for Kwai Chung lower estate residents. And then they went to see the Labor Department, etc., to no avail. Now, the evidence can be issued by the government, or they can also be sent by electronic means and messages, etc. Now, I know that for confirmed cases, it will be straightforward. They get a message and they get electronic information to say that they are confirmed cases. So those are straightforward in providing evidence. But there are situations where individuals are not confirmed cases. They are also entitled to sickness allowance and sickness leave. Let's say people or family members in the same household as COVID cases. They are not confirmed cases themselves, but they are entitled to the sickness allowance. And I know of employees and workers who do not get any messages from the government, even though they are close contacts. And another point, there should be a release from hospital certificate or evidence after 6 months or within 6 months of recovering from COVID. Now, if it is indeed a hospitalized case, that would be straightforward, but what if it is not? And what it would be admissible? Well, we hope that the Labor Department can have more communication with the relevant bodies so that there can be a minimal disputes out of these unsure, uncertain situations. Chair, we note this. We will be strengthening our coordination and communication with the health department. Basically, it is just to clarify things so as to lower the incidence of any disputes. Thank you. We have completed a discussion on policy. In the next meeting, we will go to clause by clause scrutiny. And we hope that the Commissioner and the administration, on hearing our opinions, would provide written responses to our members. For the next AOB now, it is 20th of April, 2:30 in the afternoon for our next meeting. Any other business, please? If not, we close the meeting here. Thank you.